Hi, this is Paul Hitchcock. Thanks for jumping on Wealth Protector TV. Have a great episode for you today. Let's go take a look.
Let's do a talk on some basic estate planning, because this is an area which I think when you give out the word estate plan, you get all kinds of different images in people's mind as to what it is. And so what I decided to do with this is I want to give you what I call the estate plan 101 speech. In other words, whenever I have a client that comes in and wants to engage us or consult with us regarding some basic estate planning, I want to make sure that they understand exactly what a comprehensive estate plan is, what the documents are, and what are some of the things that you need to think about. Now, by no means is this going to be comprehensive for every particular circumstance and every scenario, because estate planning can be very complicated. We deal with things with business owners. We deal with people who are recently divorced. We deal with young couples. We deal with old couples. We deal with blended families, all of which have their own unique challenges. But notwithstanding the overall family circumstance, I think it's fair to say that the majority of estate plans are going to consist of these several basic documents. I want to make sure that you understand what they are and what are some things you need to think about prior to meeting with your attorney. So one thing I always like to kind of demystify, and I want to make sure people are very, very clear at the upfront, is that estate planning is not about death documents. It's not who gets your stuff when you die. And I find that that's the first thing that people always think about is who's going to get my stuff when I pass away, whether you have minor children, whether you have no children, you have adult children. And so it's very important to understand that it's not just about who gets your stuff when you pass away. Certainly, testamentary intent is very important, and an orderly disposition of the assets is very important. But there's a huge component to estate planning which has a lot of lifetime benefits that I want to make sure that you understand that. So the first part of it, let's just kind of talk about what the three main components of a comprehensive estate plan are. The first one is going to be documents of incapacity, documents of substituted judgment. You're familiar with this. This term is called power of attorney. And power of attorney breaks into two different categories. You have the power of attorney for healthcare, and you have powers of attorney for property and financial management. So we're going to kind of talk about that and break each of those down. The second set of documents is going to be your will. Now, in a comprehensive estate plan, a last will typically is a supplemental document to a trust. The trust is the main document that actually manages and disposes of the assets, and a will is a relatively minor but important player in a comprehensive structure. Again, we'll spend a few minutes talking about wills. And then the third component is going to be a trust. Now, this, what we're going to be referring to during this these opening comments, is a typical revocable living trust. People think of these as family trusts, as living trusts, as loving trusts, whatever you want to call it. It's basically a trust. And in its most basic form, most people either as a single individual or even as a married couple will walk away with just one trust. There are circumstances, as I mentioned, whether it could be same-sex relationships, it could be second marriages, it could be just different types of assets you have, kids of prior marriages, whatever the case may be, that you may have more than one trust. You can have any number of trusts. But you only can have one will. So that's one thing that kind of pops up when we come up with a multi-trust estate plan, because the circumstances kind of demand that. And just a little bit of background on myself. I've also been doing estate planning, as Paul had mentioned, for at least at this point, 22 years. I do trust and estates administration. That is when somebody either becomes incapacitated or somebody passes away, someone has to pick up that plan, actually implement it and administer it. I also do trust and estates litigation. That's where the kids are fighting over the piano, or they're fighting over a bankrupt trustee, for example. And also, I am also a professional trustee, so clients that needs a professional fiduciary to kind of step in the shoes to take care of the family's assets because the kids are too young or they don't really have anybody that they trust in that trustee role. I also fill that role. So what I'm going to be divesting to here is really a wealth of information, a wealth of knowledge over 2 decades of planning experience as well as implementation experience, and I think that will kind of come through. So getting back to our first set of documents, Paul, you have what's called the powers of attorney for healthcare and property management. Again, documents of substituted judgment. And this is why I say it's not just about who gets your stuff when you die. Because this is also what I would like to refer to as the Rodney Dangerfield of estate plans, simply meaning that they get no respect. Everyone's always says who gets your stuff when you die, and they forget there's a big component here for your benefit. So if you're in a circumstances where you yourself are unable to make decisions, somebody needs to step in your shoes and make those decisions for you. Now, that time period, depending upon your age and circumstances, could be a 20-year long time period, 30-year long period. I had a client this morning that were in their late 30s. That could be 60 years. In other words, somebody is making decisions for you via these documents over the next 60 years of your life. Nobody's dead. Nobody died. No assets transferred to kids. Everything is for your benefit, and these documents speak for you for 60 years. When, just to give you a comparison, when someone does pass away and we are doing administration, let's say for minor children or even adult kids, okay, 18 months, you kind of gather the assets, you pay off some debts, you establish some bank accounts, you collect from life insurance, you collect some retirement plans, and boom, it's done, maybe 18 months. So 18 months when someone dies, 60 years when you're alive. So there's a big lifetime benefit for you. So the first document, as I mentioned, was the power of attorney for healthcare. Now, this is, it's pretty self-explanatory. Who makes medical decisions for you if you're unable to make those decisions for yourself? But not only are you electing an individual or appointing an individual to make medical decisions for you, this is also where you want to have an affirmative statement that says, under some circumstance, I may not want to receive medical care. So every state has some form of what's called a living will. Now, don't confuse that with a last will. The last will and testimony is what a lot of people think about as that document to transfer assets. This is a living will. And this basically is, most people are also familiar in the vernacular of the, hey, pull the plug provision, right? Pull the plug. That's what the living will is. In California, it's incorporated into our advanced healthcare directive, but this is where you get to have an affirmative statement that under very narrow set of circumstances, such as you're in a medically determined irreversible coma, or maybe you are in a permanent vegetative state, and but for that human interaction, your body would have naturally expired with a matter of a couple of months, a couple of weeks, a couple of days, a couple of hours. And really all that they're doing is artificially delaying the moment of your passing. For a lot of people, under those narrow circumstances, remove the human intervention, let your body do what it's going to do. But at the same time, the companion provision is that you still want to receive enough medical attention to alleviate pain and for your comfort. And so it's a very important document. You actually have to have that. And I always like to refer back to that very, very famous case about 20 years ago of Terri Schiavo. And most of us are familiar with that case in Florida and then the resulting media circus that came as a result of that. That was simply because Terri herself didn't have any type of clear or convincing evidence as to what she would have wanted under those circumstances. So not only do medical powers designate an agent to make decisions for you, but they also may say, under some circumstances, I want to make an affirmative statement today that I don't want medical care, therefore to minimize both the financial stress and emotional stress to my family. And along those same lines, this is also a document of guidance. And so when we work within the Advanced Healthcare Directive, we're also talking about organ donation, anatomical gifting, right? It's kind of where you get to have a say about that also. And what I found over the years that a lot of people are very gracious and they want to help their fellow human being, and they want to contribute. If they can help somebody, they want to be able to do so. So they typically on the driver's license they'll say yes, and there's a little pink dot or a pink star or whatever your state may have, indicating that you are an organ donor under the Uniform Anatomical Gifting Act. But there's no limitation. And what I found when I ask my clients the following line of questioning, I say, well, the fact that you said yes under the Uniform Anatomical Gifting, are you okay with being a teaching cadaver at the local medical school? Or are you okay with being used as for institutions for research and other type of medical research? And then they said, well, no, I really didn't mean that. What I meant when I put that pink dot on my license was I'm okay as long as I can help another human being directly. I said, okay, well, let's say so. Let's make sure we limit it so we have clarity as what your intent was. But then you can narrow it even further. Maybe no institutional beneficiaries, maybe only in my immediate family, maybe the first degree of relatives, my spouse, my kids, my sisters, my brothers, whatever, my parents. Or some people, no, I don't want to get anything. I want to be put in the ground in one piece. Okay, so it allows us to have some direction as to how we're able to use our anatomical gifting if that's what you decide to do so. And then probably one of the other important things in this document, Paul, is that you have a statement here regarding long-term care. Now, this is not a matter of how you pay for it. That may be through long-term care policies or other forms of independent financial means, but this is a statement as to how do you want to be treated under those circumstances where you require long-term care. Again, we want to have affirmative statements here. So the first thing is that most people say, hey, you know, if I can stay at home and if I can maintain my privacy and independence, I want that care brought to me at home. Okay. So long as it can be, as long as it can be delivered without me endangering my physical or mental safety. Okay, fine. But also you acknowledge that if you do require a degree of care that cannot be delivered at home, and if you require a care facility, now let's say I want one that's the least restrictive, most home-like setting, close to friends and family. I want to return home as soon as possible. I want it to offer outdoor activities and social interactions. In other words, you want to be treated with a degree of dignity under those circumstances, and you don't want to be that we all kind of have that fear in the back of our mind of being left in a wheelchair in a hallway to rot someplace. So you want to make sure that you have a statement that says that so that someone can pick up the documentation and say, you know something, my parents or my good friend didn't want to be in these circumstances, and now you have a claim, for example, for elder abuse. And but for that kind of statement, okay, no, putting in a wheelchair, fine. What do you know? You've checked out. No one knows from nothing, and you didn't say anything to the contrary. So as you can see, this first document covers a lot of area, again, just for your benefit. No one's dead yet, right? So those types of things. So now in the same vein, now we're going to turn to the second document of incapacity. So we talked about someone managing your healthcare. Let's now talk about someone managing your finances and personal affairs. So here again, you have what are called powers of attorney for property management. And you know, with all due respect, many times these documents literally can be a license to steal. So make sure whomever you designate as a fiduciary truly is someone that you trust. And it doesn't have to be an individual. Many times you may want to have two people working together so you have some checks and balances to limit that temptation to be irresponsible with your money. Because again, you can't police this. You're in that state where you're able to manage your own affairs. Or sometimes you can put two people who are both responsible, but they have the power to act independently. It all depends on the circumstances.
Brad, quick question: are you seeing a lot more of this because people are living longer than ever before because the doctors are keeping them alive? But so, are you seeing more of this long-term care?
Absolutely, great question. And that's why I'm saying these documents are so important, right? Because getting into the financial side, there does come a point in time where people who may be completely competent, they may just say, you know something, I really don't want to, I can't manage my finances. It's just too much for me. Or maybe there was a spouse and he or she took care of the family finances, and now they're deceased, and now that burden falls upon a surviving spouse. They don't know what to do. You want to have some legal documentation that enables a person, a loved one, a trusted advisor, or a parent, a child, a sibling, to be able to step in your shoes for finance purposes. You can be completely competent. It doesn't have to be only on incapacity, Paul. You can be completely I just don't want to deal with this. I'm just at a point where I can't manage this. And so again, that's also, so we see that a lot. And again, to your point that the longer people live, sometimes you may be living longer chronologically, but the quality of life may not be so great. And so maybe someone can help alleviate some of those challenges as we all get a little bit older and things aren't as easy as they were when we were younger. So here you have things like managing businesses, collecting government benefits, filing taxes, access to a safety deposit box, access to digital assets, Facebook's, online banking, claims litigation, maybe someone that hit you, God forbid, and put you in that incapacitated state. Someone has to be able to enforce your rights. If you're a beneficiary in mom or dad or sister or brother's estate, someone has to step in your shoes and enforce your rights as a beneficiary. Dealing with insurance policies and annuities and dealing with retirement assets. These are all very important things that we have to deal with financially, that sometimes we ourselves are unable. And now for my business owner clients, there's a whole different thing to think about, a whole different dimension, because I'm a married man. And so like my wife, for example, if I were to become incapacitated, my wife would step up as the primary agent, as you would imagine, to take care of all of my stuff. Now, as much as I love my wife, she doesn't know the first darn thing about running a law firm, right? So the thing is, she's not the best person to manage my law firm.
Right.
But my father, who's my partner in the law firm, he is the best person to manage the law firm. So I may have a carve out called a limited power of attorney to take care of my business asset, where my spouse takes care of everything else. My dad doesn't need to get involved in my checking account and my collecting my government benefits and dealing with my insurance policies, but he certainly wants to help me take care of the law firm because we have a common interest. So for business owners that have like buy-sell agreements, or who don't have buy-sell agreements, or maybe the definition of incapacity per the buy-sell is incapacity for 90 days or 180 days until you're deemed that trigger point in the buy-sell, well, a lot can take place in that 90-day or 180-day period, especially if you're in the middle of a sale or an exit or an acquisition or banking and financing, where you may want someone, maybe your business partner or your CEO or your CFO, to step in that shoes. Maybe they're the best person for that limited purpose, but not the best person to help pay your mortgage or to refinance your house to care for you. So those are very important documents for business owners, which leads to a different dimension on that. Yeah, Paul.
So that's fascinating. Like your spouse may not be the best one to run your business, so you detail that out in the estate plan. Is that integrated with the business planning, like the buy-sell agreement? Do those speak to each other?
Yeah, that's right. As I just mentioned, many clients that have buy-sell agreements, because remember, no one's dead yet, right? You got to remember that. So buy-sells are actually pretty clear that when someone dies, there's an exchange that happens relatively quickly. But there's also typically a provision in buy-sell agreements that says someone is disabled or somebody is incapacitated, a co-owner, business owner. So the question is, how long does somebody have to be disabled? Or how long does someone have to be incapacitated before that buy-sell kicks in, that trigger event takes place? Like I said, many times we see it's 90 days, sometimes it's 6 months, 180 days. And as I was just mentioning, a lot of things can happen during that time period where a limited DPA, a limited durable power of attorney for business management and affairs, can fill that gap while we're waiting for that time period to toll. Okay?
Got it. Okay.
So now that kind of covered our benefits for us. Remember, no one's dead yet. Everyone's kind of helping us take care of ourselves. Powers of attorney for healthcare and powers of attorney for property management, which could include, in some circumstances, a limited power. So the next document I want to talk about is the last will. So this is the last will. And so here again, everybody's going to have a will, and they do, in a comprehensive estate plan, they do two main things, Paul. The first thing that they do is, for those of us that have minor children, they nominate our guardians, right? And guardians are individuals, at least in most states, when you have a child who's under the age of 18. Typically 18, you're deemed an adult and you no longer need a guardian. You can contract and you can receive funds, etc. But if you're under the age of 18, you have to have a guardian. And you have guardians of the person and guardians of the estate. So we're talking right now guardians of the person, which most people think about actually having physical custody of the individuals. So of my 4 kids, 2 of them one is 12 and one is 5 years old. And I have 2 adult kids as well. And so my 2 younger kids have guardianship, and my 20-year-old and 18-year-old don't have guardianship. So these things change over time. The people that I had 20 years ago for my oldest daughter is not the same person I have for my youngest son now, who's 5 years old. So these things change. And I like to tell the joke that my oldest daughter is 20, and my wife and I have been arguing about guardianship for 21 years. So no one can ever raise the kids as good as you. I understand that.
Right, yeah.
But guardianship is very important because someone needs to step in your shoes to take physical custody of the children. And so here again, this may be an individual that for most people, it could be, okay, I'll give you an example of mom and dad. So when I first had my first daughter, it was mom and dad. It was mom or dad. I didn't care. Grandma and grandpa, what did I care? If either one or both of them, there was a survivor, mom or dad. Then fast forward a handful of years. Now my daughter is 14, 15 years old, and my parents come to me and say, listen, we're in our late 60s, and God forbid something happens to you and Vina. I really don't want to have custody of a teenager. I mean, now I'm like, don't worry about it, mom and dad. I don't want to have custody of a teenager either. So I totally get it. So mom and dad are now out, and I go down to the next in line. Now the next in line is my sister and my brother-in-law. Now, as much as I love my brother-in-law, and he certainly was the best man at my wedding, the anchor in that relationship is really my sister. I'm choosing my sister because she's the anchor, she's the blood relative. And so rather than it being mom or dad, I don't care, it's not Amy or my brother-in-law, it's actually Amy. But I can't take my kids and plop them into my sister's house and not also give the other parent, the other brother-in-law, guardianship. Because what if my sister is unable to sign them into the field trip, or sign them in, God forbid, to the emergency room, or sign them in and out of school for whatever reason? So if I'm plopping my kids in somebody else's household, I need to give them guardianship. But the anchor in that relationship is my sister, meaning that if there's a divorce or a custody battle between my sister and my brother-in-law, that's their problem. My kids are going with my sister, Amy.
Right.
And if my sister is unable, they do not stay with my brother-in-law. They go down to the next in line. So in other words, you can have either one or both grandma and grandpa, or an anchor person like my sister. She's the preferred spouse. So just some things to think about. And I keep on saying mom and dad and my sister. Sometimes your siblings, although it's your reflective answer to say I want my family to take care of my kids, may not be the best person. Sometimes, Paul, the best person to actually have guardianship of your kids are the people that you hang out with. It's your best friend. Right. It's the people in your community. It's the people that your kids go to school with. It's the people that you have a common interest with, common interests, common values. The kids are about the same age. Sure, it's great to put your sister on as your primary guardian. The problem is that if your sister happens to live in another state or even another country, not only did the children at age 5, 7, 10 lose mom and dad, God forbid, now you're picking them up and moving them out of their entire support structure. They don't have their schoolmates. They don't have their community. They don't have their Boys and Girl Scouts, whatever. And now they completely lose that identity as well. And that can be tragedy upon tragedy. So give it a little thought. I tell people that don't just think my sister, of course, but there may be someone better. Just kind of think about that. So,
and I've heard you say before, Brad, that when you're talking to people about estate planning, and you and I both hear the same numbers, that 60% of Americans still don't have an estate plan, is that it's human nature to think, I don't need one. Nothing's ever going to happen to me. I'm fine. Isn't that one of your biggest battles? Is just to get people over that hump, saying, do the right thing, get something in place?
Right. Well, in certain areas of my practice, there certainly is a it may not happen to me scenario. But when it comes to death and taxes,
they happen. They happen.
None of us get out of here alive, right? So procrastinate all you want, but somewhere on some calendar, we all have our number, right? So this is just a matter of just dealing with the realities of the sands of time that we all have to deal with it. And I know it's a difficult circumstances. People, it's like you don't line up to go get a root canal, and you don't line out the door to go to your estate planning attorney. I totally get it. Right. But I can tell you, Paul, with all kidding aside, that there is a huge difference in the outcome between somebody having a well thought out estate plan, somebody having a cheap off the shelf downloaded from the computer estate plan, and somebody having no estate plan. Right. Because ultimately it's not for your benefit. I'm talking about when you're gone, right? Estate planning is not for you. Estate planning is really for your loved ones that you leave behind, whether it be your spouse, whether it be your kids, whether it be your sibling, whether it be a charity or some other nonprofit that touches your heart. So absent those powers of attorney that are for your benefit, when we all are gone, it's no longer about you. It's about how did you structure your estate, your legacy for those that you leave behind. You want them singing your praise, or do you want them cursing you from the grave?
Right. Yeah, and part of my question was about getting sick or something like that, where you need the powers of health, whatever.
I understand that, but I'm saying is there's you got to have a reality check at some point.
Right. Okay,
right. And then the last thing is on still the conversation about the wills. We talked about the importance of the guardianship and some of the options that people have that don't really think about sometimes, especially with that anchor spouse. The other thing is it's called a pour over will, and most people have what's called a pour over clause, and this is where the trust and the wills kind of work together. So for most people that have a trust, there should be a companion will that goes along with it, because those two documents work together. It helps to kind of minimize your probate experience, as well as to make sure that the trust is the main governing tool for the distribution of your estate. So they work together, and it's kind of I always say there's a rule that I always say, that you can have a will without a trust. You don't have to have a trust. And in many states, and one of the benefits of being a national speaker is I get to go around the country and look at other people's probate codes and other procedures they follow. In some states, it's actually very simple. A will is all you need. It's very simple, very automatic, and it's not that big of a deal. The majority of states, however, probate is the typical nightmare that you hear about. So you want to avoid as much as possible. So if you have a will, that's fine. But the problem here, so you can have a will and not have a trust, but you should never have a trust and not a will, right? So you can have a will and not a trust, but you should never have a trust without a will.
Why?
Because it's a companion document. I don't want to get into the details just for time purposes, but they work together for probate avoidance and probate mitigation.
Okay.
And so what happens here is that when I get people and I'm reviewing their plans, and they're going to these online services and they're not quite sure what they're doing, and they give me a copy of their trust, and I say, well, where's the will? Oh, we didn't want to pay the extra $250 to get the will, and they've actually caused a potential divide in the estate. And I'm going to get to why that's going to be a problem in just a moment when we talk about the trusts. So just understand that wills not only designate guardians, but they also have what's called that very important pour-over clause, so that if you do have probatable assets, we get those assets targeted into your trust, hopefully as seamlessly as possible, because ultimately it's going to be the trust that's going to be our main dispositive tool, the main tool that we use to distribute the assets for our loved ones. Okay, so that was our powers of attorney, again, healthcare, property management, and that was our will. That was our second set. Now we're going to kind of get into the third set. Paul will probably take me another 10 minutes or so, and then we can open it up for questions. Okay, so the one thing I like to tell people is that let's demystify what a trust is, because when you say the word trust, they think this is big, complicated legal thing, and only for rich people. I don't know what it is. And I always tell people, in your mind's eye, just think of a shoebox. Think of an empty shoebox. That is a visual representation of what a trust is. That shoebox is what's going to, in the contents of that shoebox is what a trust is. You are going to create this trust. You're going to take your stuff, your house, your bank account, your stock certificates, etc., and you're going to fill up that shoebox. And you're going to be inside the shoebox managing those trust assets. So typically you are the lifetime trustee. So you are the trust maker, you create the box, you put the assets in the box, you hold them in the box as the trustee, and you have a list of beneficiaries. So when you pass away, who get your stuff? And we have special provisions that we can use based upon different circumstances as to who gets what when you do pass away. So this kind of gives you an idea of the parties. You have trust makers, you have trustees, and you have beneficiaries. And when you start out with an estate plan, you're wearing all those hats. So my wife and I are the trust maker, my wife and I are the trustee, and my wife and I are the lifetime beneficiary. I don't have to ask anyone's permission to go to the ATM machine to withdraw a couple $100. It's my money.
Right.
I'm the beneficiary, and I'm also the trustee. But when I pass away, however, now things are different. Because I put my stuff in trust and I have a successor trustee, we'll just use my dad. I got my dad as a successor trustee. I identified my kids as the beneficiary, and the assets are inside my shoebox. I've already taken all the necessary action to designate a legal fiduciary, my successor trustee. I've identified my beneficiaries, and I've empowered my successor trustee. I've empowered my successor fiduciary to manage those assets, to invest those assets, and to distribute those assets for the benefit of my beneficiary. And so since I took that upon myself, I designated and empowered these individuals, there's nothing for the state to do. There's no probate, because that's what the probate court would have done if you would have died owning assets in your name. If you died owning assets in your name and not in trust, now the court says, well, who do I give it to? Who's the person that has the power to transfer the manage and transfer the assets? There's a whole probate process involved in that. And we avoid that by creating a trust, by pre-planning all this stuff out. And therefore, when someone passes away, the successor trustee steps up. They manage the trust assets for the health, education, support, and maintenance for the beneficiaries. And then those distributions come. And depending upon the circumstances, they can come as a staged distribution at different ages. There could be long-term holds. There could be outright distributions. There could be different assets going to different people. We can be concerned about some more of the protective provisions for our beneficiaries. Maybe you love your kid, but you don't love your in-law so much, your son-in-law or daughter-in-law, and you're worried about the overbearing pressures of that in-law on your children's ability to manage the money. Maybe your kid's a spendthrift, right? You put $1 in his or her pocket and they burn it away in 24 hours. Maybe your kids have drug or alcohol problems. Maybe your kids have special needs issues. Maybe you're very charitably inclined. Maybe your child is a doctor or other kind of professional that's in a high-risk profession and may get sued. And you want to protect that inheritance from the claims of their third-party creditors. All of that can be accomplished with a very basic estate plan as long as it's set up properly. I call these wealth preservation provisions. As long as we have the appropriate wealth preservation provisions, we can create a very strong asset protection plan right within your trust for the benefit of your beneficiaries, whether it be your spouse, kids from prior marriage, et cetera, et cetera, et cetera. And then, of course, you get all the probate avoidance because our shoebox is full, so there's no need for probate, so the time and expense and inconveniences, that's taken care of. And also, we can give some relatively creative instructions, incentive-based, time-based, that you would have that taken care of. And so I think, Paul, that's kind of I think the speech on what a comprehensive estate plan is. I mentioned 3 main documents: powers of attorney that break down into healthcare and property management. You have wills, which deal with guardianship and pour-over provisions for your trust. Then you have the trust itself, which is the main dispositive tool. That's where we can really get creative and make the best use of the inheritance for the benefit of the beneficiaries.
Love it. Love it. No, good stuff. Very good stuff. I'm going to jump right in here because got some questions that people emailed in, but one I want to bring up first because this comes up a lot. And this just was last week. This situation happened. 4 kids who inherited a family vacation home. So this was in Tahoe. So you get this home. Now you have 4 different kids. And the question they're asking our firm about is, how do we, with the estate planning, how do we handle this inheritance? Now, they each own 25% of a house. Mm-hmm. And they were asking about the proper structure, too, for that house. Right. But also, what happens with estate planning when you inherit a property, 4 different kids?
Okay, so let's just start off with the inheritance of the property, and then I think the other issues will get resolved when we talk about that. Okay, so the first thing to understand is that if you simply just distribute the property, because if it just says 4 kids distributed, typically each of the children will simply take a 25% apiece, and they'll wind up owning that property equally as tenant in common, okay, among the 4 of them. Okay. We don't like that only because that property is now subject to the claims of each of those child's creditors. So if you have one child that has going through a divorce, or maybe they themselves have creditor issues, their creditor can come up and grab that 25% interest. And then the other 3 kids are co-owners with a hostile tenant in common as the creditor. So we don't like to see these outright distributions of real estate. Alternatively, what we would rather see is the trustee up at the trust level create an LLC, which is a limited liability company. And then they can put the property inside the LLC, and then they can distribute the LLC membership interest. Okay. So therefore, they're not getting the dirt. What they're getting is the membership interest, which represents their ownership. And if you got 4 kids, I have to assume they maybe not be living in the same household. Maybe they're kind of peppered around the country even. And as a result, maybe they amongst themselves agree, okay, Johnny, you're going to be the one that manages the property for the family, the legacy property. Okay, fine. That LLC structure also allows us to designate a manager that the kids agree amongst themselves to take care of the property for everyone else's benefit. That manager can be compensated for their job, so they're not kind of working for free for their siblings. And so you kind of, and now you get the asset protection. So now you have creditor issues, et cetera, et cetera. You have now asset protection. So it's a much cleaner way for the property to be distributed. And the other issue, Paul, is that although the 4 kids may like the property, maybe the 4 kids can't afford the maintenance of that property.
Yeah,
right?
yeah, that came up.
It's split 4 ways, but child number 1 simply doesn't have the money to contribute their 25% of the expenses. Right. It reminds me of my business owners. All the employees carry on about wanting to be a percent owner because they want to get their percentage of the profits. Yeah, but they forget as an owner, you also need to take your responsibility for your percent of the losses. And I was like, oh, I didn't want that part. I just want the upside, not the downside. Okay, well, there's no difference here, right? If you're going to be an owner of a property, you're also proportionally responsible for the upkeep and maintenance of that property. So maybe they may not want that. So that's a big deal. Maybe they're going to horse trade amongst themselves okay, maybe the 3 of them and 1 guy will get cashed out. Fine. Maybe mom and dad can do the responsible thing and maybe even take out a small life insurance policy to add. Here's the property as a legacy. And I've done this myself with clients. We've actually created a separate trust to put the property in. We designate as successor trustees to manage it for the legacy, for the family's benefit. And then we've also put a life insurance policy in there, something small, $250,000 term policy, whatever. So mom and dad pass away. Not only is the property held for the kids, equally, it's also the funds of $250,000 invested will help take care of the repairs and ordinary maintenance and expenses, and also pay for the trustee for the time and expense in managing it. That's the proper way to do it.
If the kids don't have their own estate plan in place, so they don't have a will or trust, you would advise them, if they now have this property, 25% interest, they need to get their own estate plan in place, right?
Yeah, I think estate plan, that's a good question, because when do I need an estate plan? And I say, well, basically, there's two, in my opinion, 2 preliminary things. One, you got kids. Okay, that's just one and done. You got kids, you now have the responsibility of somebody other than yourself, and you need to do the responsible thing and plan in the event that you aren't there to take care of them. So that's don't make them a ward of the state, okay? So if you have children, you have to have an estate plan. The second thing is, you have any assets. And for most people, it's not 20 grand in the bank. I'm talking about you got a house, maybe you have small business interest, you have interest in a business, maybe you got a brokerage account. You're not talking millions of dollars, but maybe a couple $200,000 of assets and a property. Maybe you have a life insurance policy. Maybe you have some money typed in a 401k. These are assets. So if you have assets that are maybe more than 200,000 or 300,000, even if you're not married, even if you don't have any kids, you want it to go someplace and not just get wasted. So maybe you want to designate your sister as a beneficiary, your niece or nephew as a beneficiary. Maybe you want to give it to a charity. So it's very important that you have an estate plan, right? So to your question now, if it drops down from mom and dad's plan to the kids,
right?
Do the kids have to have an estate plan? It's always recommended for the reasons I just mentioned. However, we can use mom and dad's trust as the holding tank for that kid's inheritance. So the narrow answer to your question is no, the kids don't have to have, if we set up mom and dad's plan correctly for their benefit. But I think the broader answer is that the kids should have an estate plan. Okay?
Okay. Yeah, okay, because that can get more complicated the deeper you dive into that. Brett, so you mentioned probate, and this is someone emailed in this question. Again, we get this a lot, but are assets frozen in a probate? And let's say there's 2 business partners or 2 people that own an asset, one of them, dies, doesn't have an estate plan. Are the assets actually frozen? And if so, how long? Is it disruptive to a business, to owning a property? What actually happens there?
Right. So yeah, there is what's called an estate freeze. There's a freeze on the assets, and if not in the probate area, I even do it at a trustee area. All we're trying to figure out is, what am I dealing with here, right? What are my assets and what are my liabilities? I need to net this thing out. And it's no different in a trust administration or in an estate administration. There's going to be a period of time where somebody, whether it's an executor, whether it's an administrator, or whether it's a trustee, they're going to take a step back and say, wait a second, I need to muster up all my assets. I need to muster up all of my liabilities and find out what am I dealing with. And the reason why, Paul, is because if the fiduciary makes a distribution of assets, and then there's still some liabilities, whether they're creditor liabilities or the tax liabilities, who's on the hook for that? The fiduciary. Right. So the fiduciary is not going to let anything go until they feel comfortable about that. And there's no difference on the business side of things. So it's not that there's a mandatory freeze for some prescribed timeline in a probate code. It's more the fiduciary's prudent behavior is that they're not going to want to let things go until they get their handle on what it is that they're dealing with. So I think it's more of a practical freeze than it is a legal freeze.
But if there's no estate plan, then there would be no fiduciary there, right?
No, there is. There's no estate plan. You have an executor. You're now you're in probate. So, but the two things are very analogous, right? So if you have a will only, you'll have an executor as the fiduciary. If you don't have a will at all, you have what's called an intestate estate. You'll have an administrator. And if you have it in trust, you'll have a trustee, all of which are very similar roles, just different legal capacities, but they all have that same issue. Now, but what also happens though, Paul, is that you have contests, right? Everyone's kind of complaining. I want the business. No, I want the business. No, mommy told me this. No, daddy told me this, blah, 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 blah. Now, when you have the subject property at issue, now for sure, you're going to have a freeze until the court can figure out what's going on. Okay. So it can be very, very disruptive. And after over 2 decades of dealing with this, I can give you horror story after horror story after failed business, all because it wasn't done properly in either a trust and or a stated situation.
Yeah. So is it accurate to say if, let's say, you're running an online business, Amazon seller, for example, I know you're working with a lot of Amazon sellers, and they got a thriving business. Maybe they're married, maybe they're not. They don't have an estate plan because they're young. They don't think they need one. They got this business, they're killing it, Amazon business, and something happens to them.
Right.
And what happens to the business? And can you have some sort of protection for that scenario with the business, whether they're married or not?
Yeah. So I think there's two different simple answers on that. The first simple answer is you have a buy-sell agreement, right? So,
but with who? If there's no business partner, what if it's just
okay, no business. Okay. Well, then the other answer is you have something kind of built into that. So you could have like successor managers. You could have something in your corporate bylaws that says if there's a vacancy in a particular office, somebody can kind of designate someone to kind of keep it going. But certainly, if you're just flying solo and you pass away, that stock or that LLC interest is going to wind up in your estate, and it's going to trickle down per the state's intestate statutes. So everybody has an estate plan based upon state law. The question is whether that state-based estate plan is in alignment with what you want, with your testamentary desires. So whether the person has a company, they're single or not, there may be some mechanics built into those operating documents that will allow for a vacancy to be filled, but the ownership issue is still a challenge. Typically the buy-sell works out back and forth, but if there is no buy-sell agreement because there is no co-partner, then it's going to wind up in the estate. And then that estate's going to wind up being in the kid, the brother, the sister, the parent, or whatever. And then,
Interesting.
Yeah. And then contracts get pulled. Amazon doesn't want you. The bank wants their money back. They didn't underwrite you. It just becomes a snowball of problems.
Right. Yeah. Awesome.
Yeah.
Awesome information. Brad, we're hitting up against our time frame here. I want to thank everyone for joining. Brad, as always, great information. And we will send out the link for anyone who's in attendance to sign up for the complimentary assessment with Brad. So look in your email. We're going to get that out to you probably in the next 20 minutes here. And yeah, again, any and all questions on anything Brad said, or you have other issues going on, it's all good. Brad, thanks so much.
All right, Paul, thank you. Thank you very much.